if you've been charged with a crime and there's an identification, you can get it thrown out if you can convince the court that it was unduly suggestive. Hi, my name is Lonnie Fish from the Liberty Law Team, and we represent people who have been injured or arrested here in Pennsylvania. Oftentimes, when somebody is arrested, they're identified by somebody, and sometimes they're identified by somebody that they've never met before. And sometimes these identifications come in one of many different ways. One way could be via a lineup. Another way can be via what's called a show up. Another way could be via a photo array, and a variety of different ways that you could be identified. Sometimes these procedures can be so unduly suggestive that you can file what's called a motion to suppress and ask the judge to throw the case out. The case that set the standard is called Commonwealth versus Carter, for what the Commonwealth has to prove to show that the identification was not unduly suggestive. Let's talk about that case. In that case, the appellant, his name is Darrell Carter. He was convicted by a jury on 2 counts of murder of the first degree. In fact, he received a sentence of life and a sentence of death, respectively, for that case. It stemmed from an incident in March of 1987 where he and somebody else was parked next to a car that was occupied by a woman by the name of Juanita Anderson and Glenn Brightbill. Now, the 2 people approached the car and ordered the occupants out, and eventually what happened was that they ended up shooting and killing Brightbill fatally. Anderson survived. So eventually what Carter did was he challenged the court's refusal to suppress the in-court identification Juanita Anderson, who recognized him, and the allegation is that her identification was tainted by her review of the newspaper article containing his picture 2 days after the murders. So let's talk a little bit about the standard with suggestive identification. Courts have previously ruled that in reviewing the propriety of an identification, the central inquiry is whether, under the totality of the circumstances, the identification was reliable. And that comes from a Supreme Court case called Manson versus Brathwaite. Also, the court has also ruled that suggestiveness in identification process is a factor to be considered in determining the admissibility of such evidence. And that's actually a Pennsylvania case called Commonwealth versus Ransom. A pretrial identification will not be suppressed as violative of due process rights unless the facts demonstrate the identification procedure was so infected by suggestiveness as to give a substantial likelihood of irreparable misidentification. So what will happen in practice as the criminal defense practitioner, what I'll do is I'll file what's called a motion to suppress identification, and then I'll tell the court that, hey, that we believe that in this particular instance that the identification was unduly tainted. One example of one of the most unduly suggestive procedures is what's called a show up. So let's just say that somebody is robbed at gunpoint and the police are searching and circling around the blocks, and they stop somebody who they say fit the description. So what'll happen is that sometimes they'll take that victim right to the person and they'll say, hey, is that him? Meanwhile, that person will be in handcuffs, will be the only person there. So what will happen is that the court will have to take this exact analysis that was laid out in Commonwealth versus Carter. Unfortunately for Mr. Carter, the court found that the identification was good, but let's talk about the standard that was laid out. The standard that's laid out is that the Commonwealth has to establish by clear and convincing evidence that the later identification was not the result of the earlier suggestive event. In order to meet this burden, the prosecution must demonstrate under the totality of the circumstances as an independent basis existed for the identification. They have to consider some factors, and here's 5 factors they're going to consider. Number 1, the opportunity of the witness to view the criminal at the time of the crime. Number 2, the witness's degree of attention. Number 3, the accuracy of the witness's prior description of the criminal. Number 4, the level of certainty demonstrated by the witness at the time of the confrontation. And number 5, the length of the time of the crime of confrontation. Back to our original situation in a scenario where, you or a loved one was stopped by the police, and you were stopped because you fit the description, and they round up the person who says they were just robbed or carjacked or whatever it may be, the court is going to do this exact analysis. So, for example, if they put over police radio some vague description, white male, 40 years old, 6 foot tall, that's somewhat vague. But if they describe me as white male, 40 years old, 40-some years old, black pin, straight suit, white shirt, clean shaven, short black hair, and they describe me pretty well, then there's some indicia of reliability of this sort of identification. If they also have only had a few moments to witness the person, or if they hedge their identification by saying, "No, I'm not quite sure," the court may actually throw that later identification out. So if you or a loved one has been arrested and charged with a crime, and you feel that the identification process is unduly suggestive, call us at the Liberty Law Team and let us help you win your case.